I want you to imagine this. You flee a war, you survive a journey across continents, you arrive at the US border legally asking for asylum. And an officer says, "We're not processing asylum today. There's a public health determination." No judge, no hearing, no chance to explain your fear. And here's the most dangerous part: no pandemic is required. This isn't proposal. It is not a rumor. It's finalizing DHS rule quietly issued in the towards since it began like December, that gives US government a standing authority to shut down asylum using public health. Today we're going to explain exactly what this rule says, how it works legally, why it's more powerful than Title 42 ever was, and what it means for asylum seekers in 2026 and beyond. So, the Department of Homeland Security finalized a regulation that authorizes immigration officials to restrict or suspend asylum processes when a public health emergency is determined to exist. Now, this rule is permanent unless appealed, applies at borders and ports of entry, allows denial or non processing of asylum claims. And we've been talking about this. It does not require individualized assessments, does not require congressional approval. This isn't a discretionary guidance, it's like a binding regulatory authority. So, DHS is basically claiming it's necessary for operational readiness during health emergencies, but the language goes far beyond emergency response, right? U.S. asylum law is codified under the Immigration and Nationality Act, INA, which guarantees the right to seek asylum regardless of the manner of entry. So this rule does not repeal the INA, right? Instead, it uses a legal maneuver called conditional suspenses or suspension, right? In plain terms, asylum remains legal on paper, but its processing can be halted. Rights exist without a forum to assert them. So this is a classical administration workaround, right? There is the key difference from past policies. This rule does not require a declared national emergency. It does not require CDC concurrence made public. It does not require proof that asylum seekers pose a specific health risk. It relies on executive determination, not evidence presented to the public or in court. You guys following this, right? So many people are asking, isn't this just Title 42 again? No, it's more durable. Title 42 was tied to COVID, right? Was framed as temporary, was repeatedly challenged in the court, was eventually ruled unlawful in applications. This rule, it's a disease diagnostic agnostic, right? It's future orientated, it's pre-authorized, it's harder to challenge because it's regulatory. Title 42 had to be invoked. This rule always on standby. So, and that is a big thing that really matters. You might be thinking, how is public health defined then? Right? This is the quiet part where there's not a lot of highlighting happening. Public health in this rule is not narrowly defined. That's the thing. It can include communal diseases risk, strain on health infrastructure, international outbreaks, migration related health concerns. So notice what we're missing: no requirement of US outbreak. So there is no threshold metrics here, no sunset clause. This means health event outside the United States can justify asylum restrictions inside the United States. So this creates this like a legal pathways where asylum is no longer a right, it's a conditional benefit. And if we're being honest with each other, this rule will disproportionately affect border asylum seekers, right? Refugees from conflict zones like countries like African, Caribbean, and Latin American migrants, people without attorneys, right? And I've been saying this throughout all the episodes. Like if if you are in a predicament where you're being deported or you're dealing with a situation, contact an attorney. But it's hard to do that because you don't really have the financial means. Families arriving through land borders, right? And it's not meaning it will not meaningfully impact tourists, right? Business travelers, diplomatic entrance. Public health exclusion has historically been used to regulate undesirable migrations, not actual disease vectors, which is, and it's not, that's just the history of it if you look at it. So the president's dissent is that this rule sets the asylum can be suspended without Congress, without courts, without individualized reviews. Once a right becomes conditional, it becomes political. And once it becomes political, it becomes permanent. This rule is not about 2025. It's about normalizing exclusion through administrative law, right? And are we able to, reverse this? Technically, you can. Politically, very rare. Rules like this survive administrations because they are framed as neutral, technical, and protective, right? But make no mistakes about this. This is one of the most consequential asylum changes since the Refugee Act of 1980, right? So, again, if you haven't subscribed to our channel, please be sure to subscribe it, like, comment, and share. This video is for educational and reporting purposes, so be sure to share with your friends, families, anyone that might be in need of this information. Until our next episode, Assalamu alaikum wa rahmatullahi wa barakatuh. Like, comment, and share. Bye.